All right, everyone, let's get started. I appreciate that you're here, and I know it's your evenings, and I really appreciate that you take some time to learn about some estate plans. And also wanted to say Happy Lunar New Year because that's today, and I will get started. Okay, so we are going to be learning about estate planning basics today. If you had a question about, what's a trust, like what's a will, do I need all this? We're going to be talking about the importance of that. If you do have a question that you want to ask, please just put it in the chat. Time permitting, we will get to that. And if we don't have some time, then you can email me separately or set up a consult. I'd be happy to speak with you about it. All right. And just a little bit about our firm. I know that a lot of the participants today are our clients, but just for those that don't know, this is our firm. We practice exclusively in estate planning, living trusts, power of attorneys, deeds, probate, and trust administration. We do have 3 attorneys and staff as well. We are women and minority owned business. And we have 2 offices located in Cerritos, which is close to the 91 Freeway Valley View exit. And we do have a branch office in Mission Viejo. We help clients in Spanish, and then I also speak Korean as well. And that's Stephanie Rellis there in the picture. Just a little bit about me. If you could believe it, I have like 18 years of trust and estates experience this year. This is my 18th year as an attorney. Oh my gosh, time flies. I went to school down in UC San Diego, got my law degree at the University of Pacific McGeorge in Sacramento. I'm local. I grew up here in Cerritos, and I'm currently living in Cyprus. That's just a little bit about me. And of course, I'm an attorney, right? So we got to do a quick disclaimer. So this presentation is just like very general advice, right? So, I mean, it's nothing that you want to take personally because it's just very general. There's no attorney-client relationship by this presentation. It's if you do have a specific question, you want to contact me. I discourage any type of like pictures or screenshots. If you do want some information, let me know in advance, and then, or I mean, like after this presentation, I'll be happy to share some things with you. But I don't want you to like taking screenshots and like posting on social media or anything like that. Okay. So having said that, we'll get right into it. What is an estate, right? We're doing estate planning. So what's an estate, right? Do I even have an estate? Well, it's a collection of every asset that you owned. It's everything that you own. It could be your house, it could be cars, bank accounts, furniture, jewelry, even your business too. Some other things I didn't include here, maybe like an intangible property, if you had like royalties or something, a patent, like those are just everything that you own. And that's what's included in the estate. And then what's an estate plan, right? So we are trying to make a plan for what's going to happen to everything that you own if something were to happen to you, right? And by something, I mean, of course, death, but also what if you are alive but you become incapacitated? And the question is, well, who's going to manage your things? Who's going to sign for you, right? Who's going to like handle your real estate? And if you don't have anything planned in advance, we're going to be in a conservatorship court process. Who wants to be in court? But this is where the court has to appoint someone. The bank's not going to just take someone's word for it, right? They're going to want to see some documentation. So this is a conservatorship where if you can't handle things yourself while you're alive, the court has to appoint somebody for you. And then, of course, probate, that's the process where at death now, if you don't have anything planned, or even if you do have some like a will only, you still might have to be in court because if you have an asset and you didn't write down where it goes to, like who's anyone, how they're going to know? So this probate court is the process where, okay, did you have any heirs? Did you have any debts? Like where is this process where is this asset going to go, right? Who is going to be in charge of all those things? So we have to write that down in order to avoid this probate process. And sometimes the estate plan can also assist in minimizing estate taxes. Now, the tax rate is currently $14 million per person. So a married couple, you have $28 million in assets that if you pass, if you have less than that, you don't have to pay any estate taxes. Could you believe it? But California does not have an inheritance tax. They don't have a death tax. So this tax rate, the 14 million that I'm talking about, is an IRS federal tax rate. Most people were not going to be close to that threshold. So really tax planning is not so much, we don't have to do a lot of tax planning anymore. But this is a good reminder that if you do have an estate plan, a living trust that's old, like probably more than 10 years old, you do want to review that because back then the estate tax rate was less. It was like $1 million per person, let's just say. So they had to do some special planning called like an AB trust where they had to split the trust in two for married couples. And if that's the case, you might want to review that and get it updated for today's tax law. So that's just a quick tip. All right. Basic estate planning documents. You probably heard about this revocable living trust. We're going to talk about that. A pour over will, right? So what's the difference between a trust and a will? We're going to go over that. And by the end of this presentation, you will know the difference. And then the power of attorney for finances. I'm sure you've heard of power of attorney as well. So how are we going to use that together with the trust and the will? We also prepare healthcare documents. You know, if you can't tell the doctor what to do, right? Who's the doctor like listening to if your whole family is disagreeing about what to do? And some other documents that we prepare, a living will, a HIPAA authorization, and the general assignment of property. But I'm really going to just focus on the main like 1, 2, 3, 4 documents because those are really the essentials. So the question is, will my estate go through probate? If something happens to me, is it going to go through the probate court system? It depends. It depends on what type of assets you have. Because there are certain assets that have to go through court, and there's certain assets that maybe it'll just go by way of beneficiary or like a joint account holder. But what you need to know is if you have assets that are just in your name, right? It wasn't a joint account holder, maybe it didn't have a beneficiary, and it's over $184,000, which, you know, if you have a house, like it's probably going to be more than that, then you might have to go through probate. I put a little asterisk right here next to this number because in April of this year, this value will probably go up. It changes every 3 years. I have a feeling it's probably going to be like 200,000 or more. It just depends on like the rate of inflation and all that stuff. So we don't know yet what that exact number will be. It's on April 1st, it will change. So just to add to that, will my estate go through probate? If you have just a will in California, most likely you still might have to go through probate if it's over this threshold. Now, I want to tell you about a new law. Alert, alert. There is a new law that is going into effect on April 1st. Technically, it's effective now, but it's for deaths that are occurring after April 1st of this year. If you have a primary home only, so if you have like a home plus like investments and all that stuff, it's not going to apply. But if you just had a simple house, it's under $750,000 gross, right? Don't count the mortgage. And you'd had no planning done, there is a shortened probate process that will be available now. But the problem is you still have to go through court. Maybe you don't have to go through like the 2 years of probate and, you know, costs like a lot of money. Maybe it's not like crazy probate like that, but you will have to go through court. It is a petition, probably going to be about 6 months or more. And, you know, you still might have to pay an attorney. Now, I mean, it's good because it's shortened, probably less than a normal probate. It's only in very special circumstances. So this is a new law that will be happening very soon. So we'll see how that goes. And just what I was saying, that probate is very expensive. This is like a sample fee for a $500,000 estate. Now, this is not anything that I just make up. These are like the fees that we charge. No, this is set by law. So it typically, let's say you have real estate, like I said, not counting the mortgage, it's $500,000, right? On the fair market value at date of death. The attorney's fees will be $13,000. And the executor, the one who's in charge, they also get the same as the attorneys, $13,000. If the attorney has to do extraordinary things, things that are outside a regular probate. For example, they have to help sell real estate. Maybe they have to like, you know, there's some beneficiaries that we couldn't find. They have to do all these extraordinary things, things not in the ordinary. Then at that time, the attorney can charge an hourly fee. Plus, you have these costs of administration. You know, every time I file something with the court, it's like $500, and subsequent filings are like $40, and you have to pay like an appraiser, you know, the probate referee, and you have to do all these things. It's probably going to be about $30,000 when all is said and done. And if your estate is valued at higher than 500,000, well, it just keeps going up from there. So I would estimate that on $1 million estate, we're looking at $50,000. Now, this can come, if you're going to sell the property, it comes out of the proceeds of the sale. But for those families who they only had a house, it's supposed to go to their kids, the kids can't pay for this money, like where is this cash going to come from if there's only like one house in the estate and they don't want to sell it? And this is why probate is really difficult. And sometimes I have to break the news to the clients that, oh, you have to go through probate, right? I don't make the rules here, but if they fail to plan, right, like this is the court process. Okay, so now we've established that it's super expensive. So back to my question, will my estate go through probate? Here are some assets that are not subject to probate. If you have joint accounts, right? So let's say husband and wife, they have a bank account. One person passes, it all goes to the joint account holder. No probate, it's automatic. The problem is if they're both not here, they both go at the same time, then it probably might go through probate because at that point it's like, where does it go? If you have assets that are held in the name of the trust, right? Then in the trust, we write down, who gets what happens to it. That also will not go through probate. Why? Because there's like a plan. We have like a direction of where it's going to go. Sometimes you have IRAs, 401ks. They have pay on death or beneficiaries named. It's going to go straight to them. And this is a good time to kind of update your IRA beneficiaries. Let's say you established this IRA a long time ago, your kids were minors, and you're like, oh, I can't give it to them. Maybe I'll just name like my sister as a beneficiary. And then now they're over 18, right? You might want to review that and make sure that the beneficiaries are accurate. Or another instance is maybe you went through a divorce, or maybe there was a death, right, of a spouse. Here you want to update the beneficiaries, making sure that the correct people are going to be named. Now, if you do have beneficiaries named, it's going to go straight to those beneficiaries. The trust and the will likely will not control that. So just keep that in mind. If you're thinking, oh, all of my assets are going to go to my, X, Y, and Z, you may want to do some calculations about, okay, who do I put as beneficiaries and then who do I put as trust beneficiaries? So again, life insurance and annuities, make sure you have beneficiaries listed on that. If you don't have a beneficiary on these assets and you're not here, where does it go? It's going to go through probate, where they're going to figure out where it goes. All right. And so then, okay, let's say I didn't do any planning. Well, then who's going to get my assets if something happens to me? If you have no estate plan, it's going to be whatever the California default laws are. Sometimes I have a lot of single people, they're not married, they don't have kids, and they're like, I don't need to plan, right? Those are the people that need to do the planning the most, because if they are not here, then it's going to go to the correct order would be, if they don't have a spouse or kids, to their parents if they're still alive. If the parents are not here, their siblings. If they don't have siblings, then the siblings' kids. And then if that's not there, then aunts and uncles, nieces, cousins, and so forth. And maybe that's not what you want to do, right? So thinking about California's default laws on that. And then, of course, if you do have a trust and will, then great, good job. The assets will be distributed pursuant to those terms. All right. Next is the revocable living trust now. So how does this come into play? And what exactly is a living trust? Well, if you set up a trust, it's actually an agreement. So on the one hand, it's you, your assets, your wishes, whatever you want to do. And then on the other hand is the person who's going to actually carry it out for you when you can't do it yourself, right? So it's kind of like, I trust you to manage my things for me when I cannot do it myself. Here in the trust, you're going to write down who's going to be in charge, right? If I can't do it, who's the person who's going to like carry things out for me, right? So we may have to name that. And then who gets the assets, right? So who are the people that are actually going to get it, and how and when do they get it? So just as I was saying, it's you and the person who's going to carry it out for you. So Revocable means that you can make changes at any time. Sometimes clients are like, oh, I put my assets in the trust, the creditors can't get to it. If you have a revocable living trust, maybe that's not the case. Because with revocable, it means that you can make changes. You could take assets in, you could take it out, you can update things. And because you still have that control, right? If you get sued or something, that those assets are still within your control. They're still part of your estate. There is something called an irrevocable trust, where once you set that up, you can't make changes, you can't take assets out, like you're pretty much stuck. You lose control, right? It's not yours anymore. And those type of assets are protected from creditors. You could have both. You could have a revocable and irrevocable at the same time. It's really going to depend. I usually discourage people getting an irrevocable trust. Sometimes they want to put their house in that, but it's like, it's kind of, there's tax disadvantages. You don't get a step up in basis for that. And it's just like you can't ever make changes to it. So it's really harsh. But if you might need to do it. Like if you know that you're going to be sued imminently, if you have a creditor issue, maybe an irrevocable trust is for you. You can also use an irrevocable trust if your assets are going to be well over that taxable amount. So there are some strategies for that. Okay, but in order for this trust to be effective at avoiding probate, because that's the whole point, right? We have to put things in the name of the trust. You have to manually do that. You have to literally like contact the bank, change the title with the county to put it in the trust. So it's not like once you set it up, it's not that everything is automatic. Actually, next month in February, I'm going to do another webinar about funding the trust. So what goes in the trust? Should I put my IRA in there? Should I put like 401ks? Like what happens to life insurance? Like how do I put and connect things to my trust? Does my business go in the trust? So next month, I'm going to be having a webinar about funding the trust. So stick around for that. And you can also sign up in Eventbrite for that seminar next month. But like I was saying, really important to have a trust. I had a client who had a living trust, right? They, did everything properly. They set it up, but you know what? They got this real estate later, and they forgot to put it in the name of the trust. So it's hanging outside, just in their name. Meanwhile, they have a trust, right, with other things in it, and then they passed away. And guess what? We had to go through probate for that one property that was not in the trust because it wasn't connected. So how can a trust like manage or have control over anything that's not in the trust? So really important that we fund and connect things to the name of the trust. Just like I was saying, there's something called the trustee, and this will be the manager of your assets. Keep in mind the trustee doesn't own the money, right? It's not theirs. They're just carrying out your wishes. Maybe they have to sell the property. Maybe they have to like invest it. Maybe they're in charge of making decisions. But that's what a trustee does. And in your lifetime, you are the trustee. So you're the one that's going to be making decisions, right? You're the one, maybe you have to sell things, and you are the one in charge. There's also the next person now, if you can't handle things, and the next person, they are the ones in charge. So they are the ones that, if you become incapacitated or you're not here. Now, that's why the trust is so important, because let's say you picked somebody, but then, it came time, they're not here, or they're like really sick, or they just don't want to do it. Then you would put an alternate. I usually have like 2 or 3 alternates, just in case number 1 doesn't want to do it or can't do it, then number 2. And then if number 2 cannot do it, then number 3. That's the good thing about a trust. There's always going to be somebody managing your trust and the assets in there. Sometimes clients tell me, well, I don't really have anyone that I can trust. It's kind of like a burden. Like, I don't know who to name as a trustee. I also want to mention there's something called the private professional fiduciaries. These are people, it's their job to be a trustee all day long. So they're licensed by the state of California, they have like bond, and this is what they do. So sometimes these professionals are cost effective than if you had to hire like a bank or something like that, or even an attorney, right? So let that be an option. There's also something called the beneficiary. Now, these are the people who actually get the money, right? Typically, it's going to be like your spouse, your kids, it could be like whoever you want, charities, right? During your lifetime, though, you are the beneficiary of this trust. So this trust is all for your benefit. If you become incapacitated We're using the funds, right, for your care. And if you're not here, then, you select who's next, right? So the trustee and the beneficiary, they could be the same person or they could be different. Sometimes when you have kids who are little, right, you can't make them the trustee. They have to be at least 18. So maybe you have like, your sister, brother, mom, dad, whoever to be the trustee. And then later, when the kids are older, you can always update this so that they could be the beneficiary if you want them to. And then there's also the distribution provisions of the trust, just like when and how those assets will be distributed. If you do have minors, sometimes you don't want to give everything at 18, right? Like what were we doing at 18, right? So sometimes you want to space it out, maybe, a third at 25, maybe a little bit at like, 30, whatever it is. There's also different types of distributions. I had a client who was like, it's really important for them to be educated and for them to graduate college. So then I put, okay, you have to be graduate from like an accredited 4-year degree program or something like that, or you have to be like age 30, something like that. I had a client who was like, I don't trust my kids. I'm going to hold it until age like 65. And I was like, okay, like that's fine. Let me tell you some good and bad stuff about that. But you're able to do that. I have another client who's like, I'm never going to give the principal to my kids because maybe they have like a spending problem, drugs, like gambling, like, something where they can't manage the money. And so you can put it into a trust. Maybe they only get the income that's generated and they never get all of the principal. And then when they pass, maybe you have it going to their kids if they have any. And then the next thing that we provide is called a schedule of assets. Some attorneys are very detailed and some I've seen it's just like house and that's it. This schedule of assets, though, is going to be really important to keep updated. Number one, if something happened to you, like how is the next person going to know that you have this tiny like 401k account at like this bank, right? So here all of this is we're trying to make it easy for the next person so that they don't have to like go through all the files. Did I miss something, right? So we're putting it all in one location, 401k, like this tiny bank account, that I had like 20 years ago, just things that they need to take care of. And we are also listing it because if you pass, and for some reason you forgot to put this tiny bank account into the trust, if it's listed here on the schedule of assets, then the court and everyone knows, oh, you meant to put it in a trust, and you can avoid probate that way. So it's going to be really important to keep that schedule of assets updated. Okay, now I just want to quickly go over types of trusts because there's so many different trusts out there. A common one that we use is called a separate property trust. Sometimes clients are, they're in like a second, third, fourth marriage, or maybe they got married later in life where they do have some separate property assets, or they came into like an inheritance where they don't want these assets to go to their spouse if something happens to them. And they don't want to combine it into like this joint family trust. So what they can do is they can have a joint family trust for their community property things. And then maybe they have like a separate property trust where it's like, okay, if something happened to me, those assets go to my kids, my, brothers and sisters, like my side of the family. So you can have something called a separate property trust. It just makes it like clean and separated. You can also have a children's trust. Just what I was saying is that sometimes the children, you don't want to give them the assets right away, like all at 18. Maybe you want to hold it until they're older. Another thing to consider is if you do have kids who are little, maybe if something were to happen to you, maybe you don't want to divide the assets. Say you have 2 kids into 2 right when they're like 3 years old, because if one of them really needs the money, they're going to be using all of their inheritance, and maybe by the time that they are able to get it, they won't have a lot. I feel like in real life, in a family, you don't think of your kids like that. If one child needed assets more than the other, maybe they had a medical issue or something, you'd use like your family combined assets, right, to care for one. In this situation, you can do like a children's pot, and all the assets are lumped into one, and maybe at age like 18, 25, whatever, at that time, whatever's left, it gets split. So there's different ways to even draft children's trust. A pet trust, really quickly. Obviously, you cannot give assets to a pet, but some pets are very dear, right? And treated almost like family to certain clients. And here you can set aside a certain amount of money for the care of the pets if you needed to. A gun trust. You know, they're so strict about like firearms and permits and licenses. So we really want to limit the liability. If you have a firearm and something happens to you and the trustee is holding this gun, they're not registered to it. And then it's like, you know, where'd you get this gun? And you can't just like give a gun to somebody, right? It has to go through the proper procedures. So sometimes a gun trust is necessary so that, oh, the trustee has like the legal authority to have possession of this firearm. Special needs trust is also really common. If you do have typically like maybe a child who is disabled, who is receiving government benefits, if something happens to the parent and now this child gets all of the inheritance, the government's going to be like, oh, you have money, like you don't need our money anymore. And the government benefits will stop and it'll be affected. Sometimes we don't want that, right? So if you put the assets in a special needs trust, it's designed so that you can get the government benefits and you can get the assets in a special needs trust. It's a supplement, not meant to supplant or like replace benefits. Charitable trust for charities, for tax reasons. A dynasty trust is what I was saying, where like maybe you never give the principal to the children. Maybe you hold it in trust, they get the income, but it just keeps going forever, you know, on and on to the next generation. And so many more different types of trusts out there. And very quickly about a will. So my most common question, what is the difference between a trust and a will? I just explained to you that we're setting up a trust, right? And you put the house, maybe you list the trust as a beneficiary on some accounts. Whatever's in the trust doesn't go through probate, okay? And anything else that's not in the trust name, maybe it's just an asset that you own in your name only, it's going to be covered by the will. All right, let me show you another, like a visual of how it's going to work. And if you have assets that are titled in the trust name, something happens to you, whatever the trust says, that's how it goes. But, oh, you forgot about this old bank account. Remember this story about my property? I didn't put it in the trust. I forgot. It's hanging outside the trust, subject to probate. This will is going to catch everything else that you own, and it says, I give it to my trust. So the will is just a backup. And of course, our goal is going to be to have nothing out here. But if there was, at least this will catches that. Now, if I don't have the will and you do have any assets that are not in the trust, it's going to go by the default laws of California. So that's not what I want. I want everything to be consolidated into the trust, just like we planned. Now, you might have some assets that are joint accounts or have named beneficiaries, like you got a 401k, you've got some life insurance, right? So whatever beneficiaries you have listed, that's how it goes. Then you've got trust assets, right? Goes by way of the trust. Then you might, again, be in the situation of like, oh, I have this bank account. It was just in my name. I'm not here. Where does it go? Again, will catches everything else and puts it into the trust. Okay. All right. And quickly for those who have children under 18, even if you don't have real estate, because typically if you have real estate, you should put it in a trust for California. But even if you don't have real estate, you still might want to trust because if you have minors, right? If something happens to you, how's like a 3-year-old going to like handle assets? How are they going to sign for anything, right? How can they manage your inheritance? And if they can't, it's going to be stuck in a guardianship court until 18. So we don't want that. And what we want to do is name who will be the guardian of the person and guardian of the estate. So there's two types. The guardian of the estate is usually the inheritance, the money. We have it the same as the trustees are handling the funds anyway. And then we have the guardian of the person, which is like the day-to-day, you know, going to school, making a custody and those things. You really can't avoid this court process because the court will have to decide who's in the best interest of the child at the time. But they're always going to ask, like, okay, well, who did the parents want? This is important because, you know, I've heard where it's like, you know, mom's side of the family wants to take care of the kids. No, dad's side of the family wants to take care of the kids, right? No, grandma wants to do it. No, somebody else. And then there's like this huge fight, right? So of course the court will ask, well, who did the parents want? That takes priority. You could also have a temporary or permanent guardian because sometimes the court has to decide it, but they're not going to decide like tomorrow. You might want to have a temporary guardian, like someone local who can like immediately take care until the court can decide on the permanent guardian. So again, if you have minors, so important to do estate planning. how can I avoid probate? Now that I've told you that probate is like, takes a long time and it's really expensive. Of course, some estate planning, right? A revocable living trust is a very good idea and could be appropriate for you. Also, make sure your shares of the company are in the trust. I have a client who it's spouse. Husband passed, and she's trying to sell the business, but the business, the buyers, they're like, "Oh, do you even have authority to sign off to transfer this?" Right? Because he didn't have anything in writing at the time. If it was connected to the trust, she could say, "Yes, I'm the trustee. It's part of the trust," and then she'll have authority to sign it. Keep in mind, shares of a company, that's also part of your estate. They're worth something, right? They have value, and we don't want that to go through probate. You want to be careful of how you hold title to real estate. If something is joint tenancy, if something is community property, it's good because if one person passes, it goes to the other. But at the same time, it's bad because it might go to the other. What I'm trying to say is sometimes, it's like three brothers. They're holding title to like an investment property. One person passes, it goes to the other two brothers. But what if one of them is like, wait a second, I want my third to go to my family, to go to my kids, whoever. In a joint tenancy, it would not work that way. So we want to really be careful about how we're holding title to certain assets. Okay. And using life insurance for estate planning. I do have my colleague Jeff Troy here. He's from New York Life. So if you guys have any questions about life insurance, you can ask him. But these are some strategies to use for estate planning. Funeral costs, that's so expensive right now. There's special insurance you can do just for funeral costs. And keep in mind, if one spouse passes, or maybe it's like the head of the household, you're losing an income source at death. So usually when I look at a person's assets, I think, okay, is there like a mortgage? Are there little kids, right? And we want to make sure that we have enough life insurance to take care of them. I don't want you guys to have to like sell the house, right, to take care of the kids. So if you do have a mortgage and minors, make sure you have sufficient life insurance. And life insurance can also be used to pay out beneficiaries. This happens when, let's say, there's one piece of real estate and there's like, two or more kids, and one of them is living in the house, and they're like, I'm never going to move, right? I'm never going to sell this house. Then what about the other child? How do they get their share? If you have enough life insurance, maybe it's that one of the kids gets the house, maybe another one gets the proceeds of life insurance, right? Then it's like equal. So you can use life insurance that way as well. If you do have a large estate where you feel like it's going to be over that amount, the 14 million or the 28 million, sometimes you can set up a life insurance to pay for those proceeds for any taxes that you anticipate. That's called an ILIT. And a living benefits rider. This is like sometimes you don't have to wait till death to get your life insurance proceeds. Check with your life insurance company. They could have this living benefits rider where, as part of the death benefits, if you do have like a qualifying condition, like if you're terminally ill or something, you could probably use some of that death benefit while you're alive. So that's also an option there too. I want to tell you about these additional tips. With all the fires that are happening lately, a lot of people are asking, do I have to list the trust with my home insurance? Yes, make sure you do. You should talk with your home insurance company and make sure that the trust is listed as an additional insured on your homeowner's policy. I don't want them to have to like deny a claim just based on a technicality. So make sure you do get this updated. Same for the mortgage. If you do have a mortgage, it's always a good idea to call them and update them and let them know that it's in a trust. Sometimes they'll do like a living trust, rider or something like that they do. Okay, so and speaking of fires, just want a little side note for those affected by the fires. I do want to tell you about two resources. One is from the LA County Bar Association. You can take a screenshot of this if you want to. It's going to be a crazy extensive list of just all the resources that are available. The State Bar, California State Bar, also has legal information and resources for those affected by the fires. I just wanted to put that out there. Okay, and back to our power of attorney for finances. I know that you've heard about this power of attorney. It just means that if you have any assets that are not in the trust and you become incapacitated, like who's signing for you, right? Hopefully you have this power of attorney where it names someone else to manage your finances. There's two types. One is, okay, as soon as I sign this power of attorney, the next person has immediate authority to sign for me. And there's also something called springing. I'm going to sign this now, but the next person doesn't have any authority until or if I become incapacitated. And usually in our documents, we say two doctors. I just like to get a second opinion on incapacity. Just a little quick visual about who manages your assets. If you have assets in a trust, oh, by the way, this line down the middle is like death, right? So above the line, you're alive, but maybe you're incapacitated. Below the line, you're not here. If you have assets that are in a trust, no matter what, a trustee is always going to handle things. You, then the next person, then the next trustee, then the next, right? So you're always covered in both situations. If you have assets that are not in the trust, right? Some of you don't have trusts yet. You're managing things like you do. But if you become incapacitated, hopefully you have that power of attorney where someone else can sign for you. Because if you don't, you're going to be in a conservative court process. This is where the court will have to appoint somebody. Again, the bank, a deed. They're not going to just accept anyone's word like, oh, I can sign for them. No, they're going to want that in writing, right? And then when you're not here, that power of attorney is no longer valid. A lot of clients are like, oh, don't worry about this bank account. I have a power of attorney over my mom, but she passed away. And I'm like, ooh, that power of attorney is no longer valid. And if that account was only in mom's name, we might be in probate court. So this is here again. If you did no planning, you had assets, it's not a joint account, it didn't have a beneficiary, it's just you, we might be in probate. The will is going to say where it's going to go, but the will by itself does not avoid probate. And of course, if you don't have will, then we're just at the default laws of California. Now, all of these could be the same people. It's just that maybe they're handling trust stuff here, non-trust assets here. Okay. And I know I've been talking about like finances and like real estate, but a very important part of estate planning is healthcare too, right? Because if you cannot tell the doctor what to do, right, who's the doctor listening to? This advanced healthcare directive, it names an agent, someone who knows you, who's going to make health decisions for you, who's the point person. What's also important is that it sets a priority of who's going to make those decisions. Like if your whole family is disagreeing about what to do, the person in the number one spot makes a decision. This is important, especially if maybe you're not married. Maybe you have a longtime partner. Technically, they're not related, right? You don't have that marriage certificate. So if something were to happen, they don't have a say. So that's why we got to write it down to give them authority to act on your behalf. Otherwise, it's like family members then who would have priority. This advanced healthcare directive is used not only for like the doctor in the hospital, maybe like a nursing home, and even the mortuary after death too. So it's really an important document and used to avoid, fights and like ambiguity. But keep in mind, this is not an order to the doctor. The doctor is not going to look at this and be like, oh, I got to pull the plug. No, this is just to name who's going to make those decisions. I mean, yes, I put like, okay, keep me in my house as long as possible. Like, I don't want, resuscitation or all that stuff, but it's to make the agent know your wishes. If you are looking for something more firm, like, okay, no matter what, I don't want to be resuscitated, like do not resuscitate, whatever, then there's something called the POLST, POLST. This is actually a direct order to the doctor. You could have it in your medical record. Just want to tell you about the donors, like red dot on your driver's license. Some people are like, oh, I want to be a donor. Let me put let me tell the DMV, and then they put like a little dot on the driver's license. Just be careful. Yes, it means that you're a donor, you're going to donate, but maybe tell your family members, because it also means that if something happens, they just like come and take the body, and your family doesn't really have much of a say about like what to do. If you do want to be a donor, but maybe give your family a little bit more say and options, you can fill out this advanced healthcare directive and just let them know, yes, I want to donate, but they have more control over that. Okay. And just really quickly, I want to talk about some estate planning strategies, some things that I encounter like on the daily, and things to think about when you are doing your estate plan. And these are things that like, if you go on like a legal Zoom or if you go to like a fill in the blank type attorney, they're just going to be like, okay, you want to give it to who? Let me just write it down, like without even thinking about it, right? So the first scenario is, okay, client says they want to add their child to the house deed or give the house to the child like right now while they're alive, right? This happens all the time. They're like, why can't I just give the house to my kid? Why can't I just add them to the title right now? Oh yeah, you can. The good thing is that yes, you might avoid probate because remember, joint tenancy, it goes to the other. Um, and the child is secure. They put their name on the title, right? There's some security in that. And you're maybe if you give the house completely to the child, that's it. You don't have liability. It's not in your estate anymore, right? You don't have those assets, right? But the bad thing is, is there going to be some kind of property tax consequence, right? Anytime there's a change in ownership, you know that the county is looking and they're like, okay, how can we reassess this? How can we get more taxes, right? So we want to make sure there's no property tax consequences, or maybe minimal, when doing any type of deed transfers. There's also a tax disadvantage when it comes to capital gains, right? When the next child goes to sell it after death, they might have some capital gains to pay. So it really just depends. Also, you give away your house and everything, and then the parent really doesn't have any security anymore, right? What if the child is like, you know what, I need this money here, like I'm going to kick you out? I mean, technically they could. It's also unfair for other children. This happens all the time where they're like, okay, let me just put my oldest on the title as joint, and if something happens to me, they'll know what to do, right? Yeah, they're going to keep it. That's what they're going to do, right? So we have to be careful about being fair for other children as well. And there could be some gift tax returns depending on if it's like a gift. So those are some things to consider. Um, the next scenario, client says they want two kids to split the house equally after client dies, right? Like I told you, like if you're doing like a legal thing, oh, I got one house and I got two kids. Okay, 50-50, right? But things you want to consider, okay, is one child living in the house? And what if they don't want to leave? What if they don't want to sell the house? How is the other child going to get their share? And okay, well, what if one child wants to buy the other out, right? What's the fair price, right? Who's going to come up with that? And could they even like qualify for a loan to like buy them out, right? Do they just have like, $500,000 like lying around? Maybe they do. I don't know. And can they use their inheritance, right? That's something to consider. And then what's the timeline here? Yes, I want to buy you out, but I'm in the process of getting a loan. That's like, 3 years later, right? And then, of course, what about property taxes? This is the big one here because you can't just like, oh, let me, give you $100,000 and like, we'll trade shares. That's going to cause a reassessment. So these are things to consider when you want to do your planning on real estate and like kids. Here, this happens too. What if client wants to disinherit a child, right? What to consider? Like, I have 3 kids, but one of them, they never call me, right? I've never heard from them. I really don't think I want to give them anything. Okay, then for me, I'm like, okay, what's your mental state right now, right? Are you being influenced by someone, right? Do you have an existing trust? And so these are things that I want to consider because that is I'm always looking for, okay, is that going to cause any type of litigation or fights afterwards? And then blended families, this is very typical. If if one spouse passes, should all the assets go to the spouse? Or should it be kind of like split and saved for, my kids, right? Should children wait until both are deceased, right? Because typically if you put it in a trust, the kids aren't going to get anything until you're both not here. So does that mean, my kids, let's say, should they wait till the spouse is gone? Or can they get something right now, just on my death, right? But then we have to consider, okay, if I give my assets right now to my kids, how is the surviving spouse going to live? Do they have enough to survive? And if you do have it all go to the spouse, what if they like make changes and like don't give anything to my kids, right? That's a risk. And what about the separate property? Does that also go to the spouse too, or should that go to like my side of the family or to my kids, right? So these are things to think about. And appointing trustees. Is it okay to have more than one trustee? I get this question all the time. I had a client once with 8 trustees, 8 co-trustees. I do not recommend that. But I mean, it's typical to have like, say, 2 co-trustees. you just have to keep in mind they have equal power. So hopefully they get along. Hopefully they can agree. Sometimes it could be inconvenient. A bank might require two signatures. You know, if one lives in Colorado, one's here, like how are you going to, it's going to be hard to coordinate. Another question is, can I have a trustee who is not a US citizen? I don't recommend it because for tax reasons, right? It could be taxed as a foreign trust. And if they are not a US citizen and they like, cause trouble and then like they go to like their back to their country, then it's like, do we have jurisdiction, right? Can we bring them back to court? Um, and then should I name someone other than my children? My child is really young, or maybe they're irresponsible, or like I just don't want them to handle all that. So yeah, you could name some other people too if you wanted to, but keep in mind they are the ones making decisions. And if your child does need money, they have to be like, hey, uncle, can I have money for X, Y, Z? And the uncle might say no, so we want to think about that. And what if I don't have anyone to name? Again, you can have a bank, a private professional fiduciary, anyone else that you really trust to handle things. We are at the end, and I'm sorry I talked super fast. It's just I have so much information to share with you, but we made it to the end. Thank you so much for like staying with me on this one. And I just have some closing remarks. And important to keep your estate plan organized, right? It's supposed to be updated. Just make sure like your beneficiaries are listed, right? If things have changed in your life, you got married, you got kids, like you retired, you always want to review and update your estate plan. And it's important to keep that inventory of your assets up to date, right? Because if something happens to you, like I told you, how is the next person going to know? And when choosing your trustee, carefully pick that individual. Most of the fights that are happening in probate court are between the beneficiary and the trustee, right? So you just want to make sure you pick like the right person who's going to carry out things for you. And oh my God, important to plan ahead right now while everything's good, before, I mean, who can anticipate like being incapacitated, right? You can't wait. I've had a lot of clients where I'm like, I'm sorry, I can't help you anymore because, you don't have the capacity or maybe they're not here. So always plan early. Want to tell you about my next webinar that's happening on February 26th. I don't have the Eventbrite link up yet, but if you do, check back on Eventbrite and you're probably going to get an email. For those of you who have signed up for Eventbrite, I'm going to put you on my mailing list so that you can get further updates. And that's it. So we made it to the end. Thank you so much for being with me throughout our evening. And I know your time is precious, so I really appreciate that. Okay, everyone. Thanks.